Okay, Eva, whenever you're ready.
So, hello everyone, and welcome to our first human rights webinar. It's such a joy for me to see so many of you here, to see so many new faces appearing on my screen. My name is Eva, and I am the chapter coordinator for World Youth Alliance Poland. Today, it is my great pleasure to introduce you to our first speaker, Hrvoje Vargic. Hrvoje started via Croatia chapter in 2012 and currently serves as a director of partnerships in the WIA Foundation. He holds bachelor and a master's degree in economics and philosophy, and is currently pursuing his PhD at the Catholic University of Lublin. He's our expert on the issue of surrogacy, so of course that's also the topic of his presentation today. During our webinar, you will be able to ask your questions, to type them via chat, and at the end, I will be able to ask at least some of them, hopefully, and he will answer. So I encourage you to do this. Thank you, Hrvoje, for your presence. And now the floor is yours.
Thank you, Eva, and welcome everyone for our webinar. I will now share my screen just to, Eva, I think for Eva or Elizabeth, it's disabled. It says that host disabled participant screen sharing. So maybe you can enable it for me so I can share.
You were just abled, sorry.
Okay. I will now, okay, yes, I will do it now. So I hope everyone sees my presentation now. Okay. Well, as Eva said, and as you all know, my today's topic is surrogacy. I'm glad that so many of you are interested in this topic, since it's a very actual topic. I don't know if you have seen, probably many of you have seen. Recently, there were 100 babies locked in Ukraine after being born by surrogacy. So due to the lockdown, which many countries obviously imposed, including Ukraine, there was 100 babies simply locked in the hospitals. And some said that this number could rise to up to 1,000 before the restrictions are lifted. So already this story shows us that there are many, many concerns with regards to human rights when we are speaking about surrogacy. I will highlight some of them later, but from this very actual situation, you can see that surrogacy raises many human rights concerns. Before going into the topic of surrogacy itself, I will just make, let's say, one preliminary remark about human dignity. I think human dignity should be our founding principle and guiding principle when we are thinking about human rights in general, and specifically when we are thinking about this issue of surrogacy. In the Universal Declaration of Human Rights from 1948, this is the short UDHR, the preamble of the UDHR says that human dignity is the foundation of human rights. So whenever we are thinking about human rights issues, we should first think about their foundation. And the foundation of human rights is human dignity. Now, what is this human dignity which founds human rights? This is the universal, intrinsic, and inalienable value of human persons as persons. So in other words, human dignity is a special value humans have just by being humans. So we don't need anything else. It doesn't depend on how smart, how developed, how rich, how beautiful, or whatever we are. We have it just by virtue of being humans. It is universal, which means everyone has it. So all humans have dignity regardless of anything, of their religion, sex, political background, age, and any other circumstance. It's intrinsic, that means it is somehow internal to us. We have it just by being who we are, by being humans. So, and also connected to that, we say that human dignity is inalienable. That means no one can give it to us and no one can take it from us. Yeah. So we have it just by being humans, and it's not that the state or political community or human rights organizations or the United Nations give us dignity. We have it just by being humans, as I already said. Now, Immanuel Kant, you know, probably a modern philosopher, Immanuel Kant, a German philosopher, he says that persons should never be treated merely as means, but always as ends in themselves. Now, I will just shortly unpack this issue here. What does it mean to treat something as means? What are means? Means is something that we use for something else. Yeah. So, for example, if I'm thirsty, I use this glass, this cup of water, to quench my thirst. So the goal or the end of my action is to quench my thirst. And to achieve this goal, this end, I use the glass. Yeah. So the glass is merely a means. In this action of drinking water, the ends or the goal is satisfying my thirst or quenching my thirst. Yeah? So this is the difference between means and ends or goals. Now, as Kant says, humans can never be used merely as means for something else. So humans cannot be used as objects, as glasses, or let's say as laptops. I use my laptop to do work or to achieve some other goals. And if this laptop doesn't serve me anymore, since it's my laptop, I can just dispose of it. I can throw it away in the trash. I can, even if I'm very angry, I can throw it in the wall. And I didn't violate the dignity of the laptop, because laptop doesn't have dignity. It doesn't have this intrinsic worth. Obviously, it has some worth. Let's say on the market, I will pay 500 euros or whatever, but it doesn't have an intrinsic worth. So Kant says, and I agree with that, humans can never be used merely as objects or as means. They always must be used, or they must be approached as end, as goals in themselves. We say as subjects. So I think this could be, let's say, a litmus test for any kind of human rights discussion. If we see that some policy or some law or some practice uses humans as means, merely as means, this means that this practice violates human dignity. Okay, so when we want to test some practice or some policy or whatever to see whether it respects human dignity, we should always try to see whether it uses human beings as means. If it does, that means that it violates human dignity. Now let's go a bit into the topic of surrogacy. Just check. Okay, so what is surrogacy? Surrogacy is a process by which a woman becomes pregnant in order to give the child to someone else at birth. This means that another, let's say a couple who cannot have children, asks a third person, a woman, to carry the child for them for 9 months, and then she gives up the child after giving birth, usually shortly after giving birth. The first modern documented agreement for surrogacy, even though surrogacy in history could be found already in the Old Testament and in Hammurabi's law, modern contractual surrogacy agreement was first documented in 1976 by means of artificial insemination. And then in 1988 in the US, there was a first judicial decision regarding surrogate motherhood. And then there were several other court rulings. Usually the court rulings determined that these surrogacy contracts were void. They were, in other words, null. They They didn't have, let's say, enforceability or value. They just said that these were non-enforceable and void agreements. Usually the reasoning behind those rulings was that they found a parallel between surrogacy and human trafficking. Since baby was taken from one country to another, it was used as commodity and transferred to another country. The court found parallels with human trafficking and said that these contracts are void. For example, if you would, let's say, two free persons, two adults make a contract that, or I and someone else make a contract that I will sell myself into slavery. Yeah. So I'm a free person. Can I decide to sell myself into slavery? Well, not. The courts will say that these contract is void or null. So even though I signed a contract with another person, it will be void. Excuse me. Can you just mute your microphone? Someone is has his microphone on, so I think everyone can hear some noise from the background. So if you can do that, would be great. Thank you. So let's go on. There usually, well, obviously, there can be different divisions of surrogacy. Two most common divisions of surrogacy are according to genetic relationship and according to compensation. Now let's examine the both. The surrogacy divided according to genetic relationship is divided on traditional and gestational surrogacy. In traditional surrogacy, the pregnant woman, the surrogate mother, is also the biological mother of the child. So the woman who carries the baby gives her biological material, her egg, and she's also biologically the mother of the child. She then gives up the child to another woman and another man after giving birth. Gestational surrogacy is the one in which the surrogate mother, the mother who carries the child, is not biologically related to the child. So both the sperm and the egg come from other persons. So the egg is from another woman. So she's not biologically related to the child. She basically just rents her womb. Yeah. And then according to the compensation, altruistic surrogacy is the one in which there is no payment to the surrogate mother. So she doesn't receive the salary, but she can be compensated for so-called reasonable expenses, and she can be given a donation. We will examine shortly what does this mean. On the other hand, commercial surrogacy is the one in which the woman who becomes pregnant is paid beyond expenses. It means she receives some salary for carrying the child. Now, as you can see in this photo, traditional surrogacy is usually done through intrauterine insemination. This means the surrogate mother becomes inseminated by the sperm of another man who is the intended parent, and then she herself becomes pregnant, so she is the biological mother of the child. It's her egg that becomes inseminated. While in gestational surrogacy, the surrogate mother gives her womb, but she's not the mother of the child biologically. But what happens is so-called in vitro fertilization, where in vitro, so outside the womb, the egg and the sperm are fused and the new life begins. So the baby is fertilized in vitro and then inseminated. The egg which already was inseminated, so the fetus already came into being, is then planted in the womb and then grows. So in gestational surrogacy, the surrogate mother is not biologically related to the child. Now, which parties are involved in surrogacy? Obviously, they are intending parents. So those are the parents who want to have a child. Sometimes there are same-sex couples because for biological reasons they cannot have children, obviously. Sometimes there are couples who are infertile, cannot have children, or have some other social reasons who want to become children. Then they contract surrogate mother. This is the mother who carries the child and then gives it up after birth. They're often, and in principle, there are always agencies, surrogacy agencies, which are intermediaries between the parents, intending parents, the mother, and then often also clinics and attorneys. Clinics are obviously needed. Surrogacy agencies are not health institutions. They are businesses which provide links between all these parties, and obviously they charge some fee for that. And then clinics are needed for the pregnant surrogate mother to monitor the pregnancy and to give birth in the clinics. And there are also obviously always attorneys who make sure that parties, mostly in practice, intending parents, not always surrogate, or in principle not surrogate mothers, are protected by the contract. So attorneys also pay their fees. Now, we say in the bottom of the previous slide, there was a note on altruism in this context. We say that in the first slides, the difference between altruistic and commercial surrogacy is whether the surrogate mother will be paid. Will she receive a salary for carrying and delivering the child? Now, in practice, what happens, the surrogate mother in so-called altruistic surrogacy, so the one without the payment, she's not paid with a salary, but all the other parties from the previous slides do get paid. So agencies, lawyers, doctors, they all charge fees for what they do, which in practice turns out to be that this so-called altruistic surrogacy is just 1/3 altruistic, only for the surrogate mother, and 2/3 for profit. So for all the other parties which are present in this contract, they all take profit for what they do. Other thing also is that while the surrogate mother doesn't receive the salary, she can receive gifts or donations in nature or in cash. And then also she can be compensated for reasonable expenses. So the expenses that she has related to the pregnancy and childbirth and everything that she does, she can be compensated for that. In practice, it often isn't a very big difference because she does get money. Just in so-called commercial surrogacy, it's called salary, and here it's called gift or compensation. And the difference is largely whether it is taxed. So salaries get taxed and donations and gifts don't get taxed. So the point of this slide is to show that in practice, there isn't really a difference between commercial and altruistic surrogacy. It's just conceptual. But in practice, all surrogacy is somehow commercial. All the parties have some financial stake inside of it. Now, what often happens as a result is the so-called surrogacy tourism. For example, in the UK, after the legalization of so-called altruistic surrogacy, so not commercial surrogacy, UK banned commercial surrogacy, but it allowed altruistic surrogacy. The babies born by international commercial surrogacy has grown by 200%. Then in India, it's a $2 billion market. So it's a surrogacy is a business, as many other businesses, which creates profit for those involved, and usually not for those most disadvantaged, which are surrogate mothers, but all the other parties. What is also important to notice is that surrogacy is the so-called substitute good for adoption. You know what are substitute goods? I don't know if some of you have studied economics. For example, electronic cigarettes. Do you know this new invention of electronic cigarettes? They are, for example, a substitute good for normal cigarettes, for old-fashioned cigarettes. That means if you buy electronic cigarettes, you normally don't buy these regular cigarettes, yeah? Or BMW and Mercedes. If you buy a BMW, you are most likely will not buy a Mercedes. So substitute goods is when you buy one good, it somehow substitutes this other good. Now, surrogacy is a substitute good for adoption, since increase of purchase of surrogacy reduces the purchase or taking the adoption, which is a bad thing because all the states and all the countries and all communities want to further adoption, want to promote adoption, because no community wants to leave these children in this state-funded institutions, because it's better for them to go with adopted parents. So this is one bad consequence of surrogacy. In this slide, you can see how much you should pay or you will pay for a surrogate mother in another country. In USA, in some state, well, USA has laws differing from state to state. Canada also, you would pay from $38,000 to $120,000. In Mexico is around 40, 45. Thailand from $45,000 to $8,000. In Armenia, it's the cheapest. You can go, and also in Russia and Ukraine, it can go already from $25,000 to $60,000 or $80,000. In Georgia, it's also very cheap, $16,000 up to $35,000, and then in India a bit more. So these are some prices or in the countries which legalized surrogacy. So you can see how much the intending parents usually pay for a child there. Now, how surrogacy works, a bit more to explain how this happens. It usually happens through formalized agreements. Usually intending parents find an agency. So the parents who want to find a surrogate mother, they find an agency, which then finds the surrogate mother. So they link them together. Then intending parents and the surrogate meet and sign a formal agreement or a contract where they will settle how all the expenses will be handled with regards to pregnancy, how some possible problems will be settled, and then try to agree how this will be settled. Now, the biggest question is what interests are at stake. So obviously the intending parents have the interest in getting the baby and paying for it, and then or paying least as possible to get a good quality service. And then surrogate mothers are in principle always women in need of money, who are poor and with less opportunities, who then want to get paid for their wombs. Now, another thing, well, I will mention this shortly now. So what happens is then after signing the agreement, the surrogate mother becomes pregnant. This usually happens through artificial reproductive technology. Why? Well, usually intending parents want to use not the material from the surrogate mother, but their own if they're a male and female couple, or from some other donor, egg or sperm donor, which matches some criteria they find attractive for their child. Then in vitro fertilization happens, and then the embryo of the child is transferred to the womb of the surrogate mother. Obviously, there are many risks and ethical concerns with this. Some of them are, what if some embryos are destroyed in this, which usually are in this process. Another is, what if, let's say, the in vitro fertilization succeeds, but with too many children, with too many embryos. As you maybe know, in vitro fertilization is usually done that more eggs are inseminated to increase the likelihood of conception. Yeah? So sometimes it happens that in vitro fertilization, 3 embryos are created. Now, what happens with these embryos? Are they, let's say, extra 2? Are they destroyed, or are they inseminated, or what happens? Sometimes also, so this is sometimes foreseen in the agreements, but not always. And then the question arises how to deal with these issues. Then obviously the pregnancy happens, which needs to be managed. Now the question is, what is then the relationship between the surrogate mother and the parents? Intending parents are in principle always in another country, let's say in a Western country, in the US or Canada or Australia, and then the mother is maybe in India or Ukraine. So how the pregnancy is managed, and will the intending parents be involved in the pregnancy at all, or to which extent? And also important decision is how to make health decisions. As you know, maybe pregnancy is a specific situation where many health issues can arise for the woman. Now, obviously, the big question is how to approach these issues. Who decides? Usually the woman, with an informed consent on the advice of the doctor, she would give her consent for the treatment or how to proceed with the pregnancy. Now, since there are intending parents also involved, the question is who will make the decisions and on which basis. We will address some of these issues later. And then also the question is how the intending parents, which are often in another country, can make sure that the surrogate is taking good care of the baby. You can, there are some documentaries on YouTube which you can watch. One of them is called Google Baby, where you can see how these clinics in India look like. Usually they are very, let's say, in poor conditions, at least for Western standards. There are many of these surrogate mothers in one room. They receive treatments and food and nutrition, but not in a very, let's say, good level as you would expect in the West. And then obviously the question is, what does the surrogate mother do outside the clinic, since she's not in the clinic the whole 9 months? So is she taking care of the baby and the pregnancy properly? That's a big question also. And then obviously psychosocial effects on the surrogate and her family. So as we know from medical science, the health hormone connection, the hormonal connection between mother and the baby happens already in the womb. So, and especially after the baby is born. So the surrogate mother develops emotional and psychological connections to the baby. And then the question is how to deal with that. Can this leave psychological consequences, emotional consequences, both on the mother and the child, etc. And then after birth or at birth or shortly after, the child is given to the intending parents. Now, then the question arises, who are child's legal parents? The intending parents or the surrogate mother or the donors. So sometimes the donors of the sperm and the egg are not the intending parents, but some third parties. So how do we determine that? And what is the child nationality? For example, if the surrogate mother is from India and the intending parents are from the US and the donors are from somewhere else, how will we determine the nationality of the child? So this is how surrogacy happens, and then I will examine shortly the discussion about surrogacy in international law. Usually the proponents of surrogacy speak of the right to a child. Now we will examine, is there such right in international law? Before we do that, we should understand that international law is done in two basic ways. One are the treaties. Treaties are obligatory documents which are signed by the state parties, which oblige them to implement this treaty. So for example, United Nations have a number of these treaties, like Convention on the Rights of the Child. That's one of the treaties which is obligatory. Then Convention on All Discrimination Against Women, then International Covenant on Civil and Political Rights, and many others. So these treaties are signed by the member states who ratify this treaty, and then this treaty is obligatory for the states to implement. Other way is so-called custom. This is customary international law is when some practice exists and is done by the states out of the belief that the international law obliges them to act in this way, even though it's nowhere written. So it's not written in the treaties or anywhere else, but states consistently act in such a way as though they would be obliged to implement certain practice or policy. So many things related to, for example, diplomatic immunity and diplomatic law was like that. Before there were treaties codifying the international law regarding diplomacy, for example, there was diplomatic immunity for the ambassadors in another country. So this was practiced by all states, even though it was nowhere written. But as it was a custom, it was a consistent practice, it was considered a part of international law. Now, the right to a child or right to surrogacy is nowhere written in the treaty law, and it cannot be said that it's a part of the custom since it's a new practice. There is no consistent acting by the states that we can say there is some kind of customary law with regards to surrogacy. So it's not a part of the custom. Now, is there a right to a child in the treaties? Also, no. None of the treaties mention this kind of term. So there is no term which would say there is a right to a child at all in any of the treaties. There are the closest things which we can find to the right of the child. It's in the ECCPR, that's International Covenant on Civil and Political Rights, in the Article 23, which says that there is a right to marry and found a family, but it doesn't have anything to do with right to a child. It's just meant as a freedom from state interference with marrying and reproduction, meaning a state cannot interfere in the choice of the marriage partner for men and women. That this is usually how it's framed. Then CRPD, another convention on the rights of persons with disabilities, mentions that persons with disabilities have the right to have children, but again, this is understood as the right from freedom from interference on fertility for persons with disabilities, meaning that we shouldn't sterilize or make infertile persons with disabilities against their will, because that would violate their rights. And then CEDAW, Article 16, CEDAW is Convention on Elimination of Discrimination of all forms of discrimination against women. The right to decide freely and responsibly on the number and spacing of their children and have access to information, education, and means to enable them to exercise these rights. This is again understood that state cannot impose. This was in response to forced abortions and forced sterilizations as methods of populational control, that states cannot impose the number and spacing of children to people. So key takeaway is that there is no right to a child in the international law, and when this is mentioned in a debate about surrogacy, it should be dismissed as unfounded in international law. On the other hand, there are many mentions on the rights of children. So surrogacy raises serious questions about children's rights. So here are some from the Convention on the Rights of the Child. First, children have the right to know and be cared for by their parents. This is often a problem in surrogacy when there is a third-party donor, let's say a sperm donor, who likes to remain anonymous. So often sperm and egg donors prefer to be anonymous. You just know certain characteristics of them. So the child cannot know their parents, and international law says that children have the rights to be known by and cared for by their parents. Then right to identity, nationality, and obviously prohibition on trafficking in children. So we said already that sometimes surrogacy has some characteristics which make it very similar to child trafficking. Right to a nationality, it's a big problem, as we will see now in one of the examples, how children born out of surrogacy often don't have a nationality. Then Oviedo Convention now in the European context, since we are hosting the Polish human rights webinar, a bit of the European context. One of the conventions of Council of Europe prohibits the use of human body for financial gain. So this again speaks against surrogacy because human body here is used for commercial gain. European Parliament, in one of its reports on human rights and democracy, also condemned practice of surrogacy. This is a non-treaty document. It's a non-binding document, but still it shows the commitment of European Parliament to tackle this issue, and where it condemned surrogacy because it undermines the human dignity of the woman, since her reproductive functions are used as a commodity, and then it condemns it because it exploits human body for financial gain and uses vulnerable women in developing countries. And another amendment in the same report, again, recognizes victims, women harmed through surrogacy and other things. Now, one case study to see how this works in practice. There was a baby Manji. So what happened is that the couple from Japan contracted a surrogate mother from India who became pregnant with the intending father, so the one from Japan, his sperm and an egg from an unknown donor. So not from the intending mother, but from a third-party donor whose identity was not known since she was anonymous. Then what happened is that the intending mother, the one who, together with intending father, who contracted with a surrogate, divorced intending father before the baby was born and said she doesn't want to have anything with the child. Yeah. So this shows how many problems emerge in surrogacy context. This is not the isolated case. There are many case studies like that. Now what happened next is that the intending father, who was also biological father because he gave the sperm, he wanted to raise the baby. So what now the question is, who is the mother of the child? This newborn baby had three mothers. The mother who signed the contract, who should have this so-called right to a child, then the surrogate mother, and then the donor of the egg, who is the biological mother. Now, the question is which nationality does the baby get? Usually, the baby, now, okay, we will go into that, but usually the baby gets the nationality of the mother because there is a principle that the mother is always certain, because it's not always easy to determine who is the father, but the mother who gives birth is in normal circumstances always certain. We'll come to that now shortly. The problem was that the father wanted to raise baby Manji, but single men are not allowed to adopt children and to be taken abroad from the country, from India to Japan, the child must be adopted. So in order to take a child from one country to another, the child must be adopted, otherwise it would be human trafficking. Yeah? But single men, by law, are not allowed to adopt a child. Now, what happens with baby Manji in these circumstances? Who is going to raise baby Manji and how? How to resolve this situation? Now, as I said, who is the mother? There is a principle in law that mater semper certa est, that's from the Roman law, which means that woman who gives birth is the mother of the child. This was a legal presumption because it's the easiest to determine. So the mother who gives birth is legally considered to be a mother of the child, and then the child gets her nationality and otherwise becomes identified by the law, before the law. Now, if the woman who gives birth isn't the mother, then who is? This legal presumption becomes undermined. So what means that the judicial system needs to operate in this situation in order to determine the legal parenthood. By the legal parenthood, which means law recognizing as such who is the parent of the child, is here to protect the interest of the child, his right to identity, his right to nationality, etc. Now, this is not anymore the case because we don't know who are the legal parents. As we have said, baby Manji was found to have 3 mothers and unknown nationality at the moment of his birth, her birth. So as we said, children generally receive their nationality from the parents, and then nationality is not an irrelevant thing. Sometimes we in modern discussions tend to think of nations as something abstract, etc. Well, this can be maybe like that in theory, we can discuss it, but in practice, nations do give you some rights. They protect some of your rights. So if you are a citizen of a certain state, the state protects you by law and gives you certain rights, etc. So nationality has implications for birth registration, residence, voting rights, identity, passports, and many other things. And so how to resolve this situation? If baby Manji cannot be adopted by her single father, can her father take her to Japan? But if yes, how do we prevent in similar situations that human trafficking doesn't happen? If you can just take a child from one country to another without adopting it, what happens? Now, finally, what happened with baby Manji is that grandmother, the mother of the biological father, was granted custody. And then grandmother was able to take it in Japan. And then in Japan, the biological father was raising him, but grandmother was granted custody. So in all this story, you see how baby Manji was somehow considered secondary, or his rights were violated in several occasions, while the grown-ups were struggling how to determine these legal things. Another concern with surrogacy is that it often deliberately removes a child from one or both biological parents. As we said, the child has the right to be known and cared for by her parents, and then surrogacy removes him intentionally at the moment of birth from one of his parents. Now, one question about surrogacy contracts. Usually in the contract law, there are two basic types of contracts. Sale contracts, where we are selling goods, and provision of services. So selling of goods is, for example, buying a car or a house. You pay a certain money and there is a transfer of this good, of a car or of a house, to you. Provision of service is like getting a haircut. There is no good which becomes transferred, but you just get a service of haircut and you pay for this service. Now, the question is whether these contracts are more like buying a car or more like getting a haircut. So is it more like a sale contract or provision of services? Now, if it's a sale contract, then the child must be a good, or the object, like the car, which becomes transferred. Now, obviously, there is a big problem with that because children becomes commodified. It becomes a commodity. And as I said in the first slide, it's obviously treated as an object. Objects are bought and sold. We transfer them. So the children are commodified. And then this is where the similarity to human trafficking happens. Other thing, if pregnancy is a service, the problem also arises because pregnancy is fundamentally different from any other service, since it involves the whole woman's body and all of her psychological, emotional, hormonal, and other processes. When you get a haircut, basically the hairdresser just gives you a certain part of his service. Now here, this is much more connected to mother's overall being. She becomes much more connected with the child. And the question is, can the womb be a commodity again for renting? Can we rent a womb? So the presupposition behind this is that some things cannot be for sale. There is a good, if you have time to watch it, by Michael Sandel. He's Harvard Law School professor. He has a series of lectures he delivers in Harvard in YouTube called "What is Justice?" So if you have time, you can watch that. So in one of these lectures, he speaks about the things which cannot be understood through market mechanisms. For example, if someone if you would rent someone to deliver a speech on your wedding. So your wedding starts, and then he says, well, I'm here a contractor, I'm here to deliver a speech, and then he finds from the internet all motivating phrases, and he says this in your wedding. We would find that there is something strange in that. Obviously, it's not as surrogacy, but we see that already intuitively that market mechanisms are not applicable in all situations, and this also relates to renting of the human body. And then the question is, for these contracts to be enforceable, the contracting parties should be at least in principle equal. Now the question is this the case with surrogate mothers who are usually in dire financial circumstances? Well, we can skip this to go a bit faster and to come to your questions. Another case study to find how this works in practice is babygamy. So the intending parents contracted a surrogate mother from Thailand who became pregnant with twins. And one of the twins had Down syndrome. This is babygamy here in picture. But the intending parents ordered just one child. They didn't want two. So they told to the surrogate mother to abort babygamy. But she said, I won't abort it because of my Buddhist beliefs. My Buddhist beliefs prohibit me to abort a child. So she said, I will take care of babygamy. And then there was also a big crowdfunding campaign to raise money for Gami's treatment. Now, what happened is that both the intending parents and the surrogate mother wanted to access the funds for babygami's care. So they didn't want the babygamy, but they wanted funds, which were raised through crowdfunding. So, but there was also the agency in between, which told the intending parents that the surrogate mother doesn't want to give him up, and they told the surrogate that the intending parents don't want to give him. So this was a complicated story. What the family surname was Farnell. So Mr. Farnell, who was a sperm and donor, they eventually wanted the other child, so the twin. Babygamy stayed with the mother in Thailand, the biological mother, and they took a twin to Australia. What was later found out that Mr. Farnell had a conviction for sexual abuse of a minor girl and had restrictions to access minors. Yeah, so he was able to get a twin baby from Thailand, because these restrictions were not known, because this was a private contract, so they weren't able to check these restrictions. And in the end, babygamy stayed in Thailand and twin with Farnells. Now, why this thing about Mr. Farnell, who had restrictions, was important? There is a connection to adoption. When we consider the relationship of surrogacy of adoption, there are two important differences how surrogacy differs from adoption. First, in adoption, you can never give up the child or adopt it before birth. So it can only happen after birth, while in surrogacy, it happens before birth. Yeah. An important reason for that is that adoptive parents must be evaluated. So, as you know, when you sign up for adoption, there is a screening process, which is usually very extensive, to see whether you are fit for adoption. And as we can see in surrogacy, there is no such process. It's a private contract. For this reason, Mr. Farnell, who was convicted of sexual abuse of minors and had restrictions, wasn't screened, so he was able to get the twin baby to Australia to raise him. Adoption, in difference to surrogacy, is a child-centered process. So the focus is always on the child. Adults can express their wish to adopt a child, but they are not in the center of the focus. It's not their wish to have a child in the focus, but the best interest of the child are in the focus. So the parents are screened and evaluated and tested to see whether they will do a good job of raising this child. And obviously after they adopt the child, they are screened also afterwards. So there is a social service who does some checkups on a regular basis. Now, women who become surrogates are often in a financial need, as we said. So they are basically in poor conditions. Normally, no woman would decide to do this unless she doesn't have a better option. If you can earn money as a woman in other ways, you normally would choose all the other ways than this one. So women who are surrogates are often in a desperate financial situation, and this means that they cannot negotiate on an equal footing. But nota bene, as we would say, sometimes it also happens that surrogate mothers can exploit intending parents. They carry the child and then they, how do you say, I lost the word. Basically, they're blackmailing, let's say, the intending parent, saying, well, you should give me more money if you want me to treat the pregnancy properly, etc. So this sometimes also happens. Okay, we already said this. So many of we'll finish with the laws. Many countries don't have laws on surrogacy. I think most of the world's countries don't have laws on surrogacy, so it's simply outside of sphere of law. Then this makes it hard to enforce surrogacy agreements. So you sign a surrogacy contract, but there is no law to enforce it. So this surrogacy agreement can happen, even though if you want the state to enforce it, for example, if one of the parties is not doing their part of the agreed work, there is no way to enforce it. So many things obviously can happen as a result. Obviously, there is a gray market, which normally happens in every country which legalizes it. And then there are countries like US and Canada where practice differs and laws differ by states, which means that regionally or on the whole level, the ban is unenforceable because a particular state has its own laws which should be respected. And then if the surrogacy happens, then the question is, what should we do with it? That's why many cases are in the European courts, well, not many, but several cases are in the European Courts of Human Rights, which happens after, for example, Italian parents go to Ukraine, they rent a surrogate mother, they buy a child there, and then they want to come to Italy, which doesn't, or let's say to France or another country, which doesn't allow surrogacy. Now, what happens with this baby? Will they be allowed to adopt it? Will this baby be given French or Italian citizenship, etc.? So here are some countries. This is obviously not an extensive list. Countries that allow surrogacy are Georgia, India, Russia, Israel, Ukraine. These countries prohibit only commercial surrogacy, but allow this non-profit surrogacy, or altruistic surrogacy. Australia, Brazil, China, Netherlands, Thailand, Denmark, and the UK. France, Germany, and some others prohibit both commercial and altruistic, and countries like Japan and Mexico don't have clear laws. Here is a bit of the map of Europe. This, I think, needs to be a bit updated, but you can have the impression of how it looks like. In black areas, so in these Western countries, all surrogacy is prohibited. Red countries prohibit only commercial surrogacy, and then in green ones, there is no explicit law. So it's regulated in different ways. As a conclusion, I would say that surrogacy definitely violates human dignity, since it treats persons as objects. It does so by treating children as commodity, so it definitely treats them as objects. It devalues women by treating them as incubators and reducing them to their reproductive capacities. So again, dignity of surrogate mothers is violated, since again, the mother is treated as an object for another end to deliver a child, etc. And then it also exploits the would-be parents or intending parents' desires for children and commercializes parenthood. These issues cannot be regulated away. What does this mean? Sometimes it is said in international law arena that we should prohibit commercial surrogacy, but we should tightly regulate altruistic surrogacy. So if I have an example, so this was one of the examples of a report in Council of Europe, which dealt with surrogacy. So this report said for-profit surrogacy or commercial surrogacy should be prohibited, and altruistic surrogacy should not be prohibited, but it should be tightly regulated. But as we said in this slide, these issues here, even if tightly regulated, cannot be regulated away. They remain, that the children are commodities, that women's surrogate mothers are devalued, etc. So even if you regulate it most tightly possible, you still didn't regulate away these violations of human dignity. Now, what would we recommend in turn? First is to promote investment in human capital and what people need to drive, so that women don't feel like they must rent their wombs to get finance and so to survive or to help their families, so that no woman needs to engage in surrogacy by being a surrogate mother out of financial necessity. So we should invest in human capital so that this doesn't have to happen. Other thing is always putting children's interests first and promoting child-centered alternatives such as adoption. We said that adoption is always a child-focused, so child-centered practice. So we should promote practices like that. If we would promote surrogacy, we said surrogacy is a substitute good for adoption, and this would mean going contrary to children's best interest and substituting the practices like adoption, which promote children's interest. And finally, educate people about their fertility and provide medical care so that they can make informed decisions about childbearing. This also includes investment in treating infertility, because this wish by couples to have children is legitimate. So we should invest in treatment of infertility, definitely, to address that. I will skip this report and I will go to your questions. So I will first take some time to address questions that you submitted through the form when you were applying to the webinar, and then there will be time to address other questions which maybe arose now during my presentation. So first question says, greetings, I would like to ask, how can the civil society efficiently advocate in favor of the process of surrogacy? Because the unfortunate reality in some societies, mostly in developing countries, surrogacy is considered a taboo due to the fact that a set of negative conservative ideas prevent couples from using this method in order to become parents. Well, as you can probably imagine from my presentation, I wouldn't advise you to advocate in favor of surrogacy. I would advise you to advocate against surrogacy because it's against human dignity. And what I would also say is that, as you can see, I argued against surrogacy on the basis of human dignity. I think human dignity, as it is present in the Universal Declaration of Human Rights, is not a conservative or liberal idea. I think also this question about surrogacy, we shouldn't think of it in left, right, conservative, progressive, or whatever terms, because these terms, I think, cannot capture the essence of this, what we are talking about. So I would urge you to look beyond the political divides and see if this practice violates human dignity. I would argue yes, and then advocate against it. As an example, this last report that I mentioned from Council of Europe, let's say the interest groups which opposed, and politicians which opposed surrogacy, which wanted to prohibit it, the strongest alliance was between feminists on the left, socialists, Christian Democrats, and some conservatives. So all these groups oppose surrogacy from their own different ideological or philosophical viewpoints. So both feminists and Christian Democrats opposed it, maybe for partly different reasons, but they both understood how dangerous surrogacy is. So this definitely shows that opposing surrogacy is not a conservative idea. It's present on, you can see many feminists. I mean, if you Google their websites, also the photos I used here are mostly from feminist websites. So you can see that this is not really a left-right thing. Could you argue that surrogates may be seen as property? I would say yes, they're treated as objects. Property is an object, which is treated as means. So my answer is yes. I think I already elaborated that in the presentation. If I opt for surrogacy in order to avoid bearing the labor pain myself, will I be respecting the dignity of the surrogate mother? I would say again, no. So you wouldn't be respecting the dignity of the surrogate mother. Why? Because you would be considering her as means to avoid your labor pain. So while I do acknowledge that labor pain can be difficult, even though today I think, well, from the example of my wife and many women I see around me, today labor pain can be managed to quite a high extent. You know, there is this epidural, it's called in English like that, epidural injection, which basically eliminates labor pain to a very high extent. And there are other medications, so I think this can be treated in a quite a good way today. How surrogacy has affected each person's human rights, especially the children? Well, we mentioned several rights of the children which become violated: right to nationality, right to be known and cared by the parents, right to identity, etc. So all these rights which are protected by the treaties, human rights treaties, become violated. Another question, I have had a boss tell me one time that she was going to a sperm bank because she had a right to a child. How do we address the myth of right to a child, which is the root of both surrogacy and sperm banks, especially in the workplace where free speech and conscientious objections can have negative consequences? Well, a right to a child, I think I addressed in my presentation. Obviously, there is no right to a child in international human rights law. So if you happen to discuss this issue with some of your co-workers, you can simply say that, I mean, it's understandable that people think that it can be like that, but factually there is no right to a child in international law. And this is also understandable. There cannot be a right to another person. Even if you biologically conceive it, you don't have a right to a child, because child is a subject of rights, not an object of rights. Yeah. So we distinguish subjects and objects. Child as a person is always a subject, a bearer of rights. So the child has rights. The child is not a right of anyone. Yeah, it's not an object of rights. The child is a subject of rights. Now, how to address this in, let's say, in the company, in the workplace? I don't know if you work in the person who has this, you work in a hospital or somewhere where this is relevant, or you simply work in another place where this happened to be a topic of a discussion. Well, I would say if you are asked to do or to say anything against your conscience, you shouldn't do that. You should stay with your conscience. This is, I think, more important than even with the price of maybe losing the job or whatever, even though the law should normally protect your conscientious objections and free speech. Now, this doesn't mean that if you have positions which are different than your bosses, that you necessarily have to push them in forefront of your discussions with your boss. You can be prudent in what you will say, obviously, and you don't have to put this as a main topic of a discussion. But if anyone would pressure you to do anything against your conscience, you shouldn't do that. And normally the law, international law, protects you. And then, another question, Malta does not give room for surrogacy. However, statements have been made that it it's now time to start discussing it internally in order to enhance treatment for infertility, quoting the Minister of Health. What we may do in the meantime, knowing that it is indeed being discussed internally. Well, firstly, what I would say is surrogacy is not treatment for infertility. You don't treat infertility by surrogacy. The couples who engage in surrogacy remain infertile. Huh? So it cannot be understood as a treatment for infertility, definitely. Now, what should we propose as an alternative? Well, definitely treatments for infertility. I guess some of you know, maybe not all, about FEM, which is a sister organization to World Youth Alliance, which deals, among other things, with medical treatment of infertility. They are great in that job. They're advancing the science, and they are publishing up-to-date papers and clinical studies of how they treat couples who are infertile or individuals. Or often infertility is not like a permanent infertility that you don't have any chance of conceiving, but you are not able to conceive for some time, for a year or for some longer time, and the root causes of that are often not known. So people just think they're infertile, but many times it's just going deeper into doing more tests, doing changing the treatment, etc., trying, and then many people are able to conceive afterwards. So I would say the government should support this kind of programs, FEM and other scientific programs, which do treat infertility, and this would solve a lot of the present issues. Many couples regard the idea of raising a child who's your own flesh and blood to be eminently desirable, and that's one of the reasons why they would consider surrogacy over adoption. Would you therefore say that in order to make surrogacy a thing of the past, our societies need to start placing a lot less importance on the idea of having a biological child? My answer is no. I don't think we should, that we can do that. I think that the desire to have a biological child is, as you say, is eminently desirable, is somehow natural to us. And I think we cannot just ideate it away or socially engineer it away. And we shouldn't try to do that, I think. So I don't think we should make this the idea of the past. And I don't think we actually can. Even if we would propose some propaganda on the government level, I don't think we would be able to do that. It's a natural desire. We should recognize it as such, and we should respect it, but at the same time, we should broaden the perspective. So this is a natural desire, but then there is another child who has rights, which cannot be an object of my transfers or of my wishes. There is a surrogate mother who cannot be treated as an object, etc., etc. So I think we should raise awareness of the broader issues at stake and not negate this legitimate desire. And obviously, we should do all we can to, where it's possible, to help these couples to become pregnant. I'm interested in how the best interests of the child are ensured under surrogacy agreements. Well, as you've seen from my presentation, they are often not. In principle, they are not ensured. So that's the intrinsic problem of surrogacy agreements. Now, the other question is, after these surrogacy contracts happen, what to do with them? So European Court of Human Rights had many situations like that. As I mentioned, there was this Paradiso and Campanelli case where the couple from Italy bought the child in Russia and wanted to adopt it in Italy, but Italy didn't allow it, etc. Now the question is, what should we do when this already happened because of the different laws in different countries? I would say, again, best interest of the child should be our focus, and this is normally the focus of European Court of Human Rights, and then the court decides on the case-by-case basis. Sometimes it allows the parents to adopt the child, sometimes it leaves them with the government agencies or finds different solutions. So basically, the court tries to recognize what would be the best interest of the child in each of these cases. But obviously, it's already bad that the child was put in the situation like that the court must decide about him or her. Do you agree with UDHR in I guess this should be European Convention of Human Rights. The answer is yes, I do agree with it. Which elements might be problematic from a human dignity perspective? How can we act, and what are the dangers of human dignity approach? I think I already discussed most of this. I would conclude with how can we act on this. I would say that the answer is probably the same as with all the other questions in terms of human rights or whatever just cause we want to strive for. Obviously, is to educate ourselves and then others, to raise awareness about these issues, well, through webinars and other forms of raising awareness, through public campaigns, through social media, through discussing this through social media when it happens in your surroundings. Obviously, by trying to influence laws, if like in Malta, if there is law being discussed, then organizations like Hrvoje or any other friendly organizations there should try to influence this law to respect human dignity and not to treat humans as objects. And then obviously to try to raise the awareness in the whole society also on this legal change, but also change of the mindset. I think this is the last question. Yes, it is. So thank you very much. I think we have some more time still. So Eva or Elizabeth, I don't know who maybe can share some questions from the audience.
So thank you, Hrvoje, so much. I think it was very interesting, your presentation, and it gives me a lot to think about. I guess it's the same about you. So we have new questions coming, and I will try to ask a few. So the first one is, in a family situation when the person can be pregnant and some relative generates the children, is it a special case or human dignity would be violated?
Oh, I see the question. I'll just shortly read it now. And Matteo, excuse me, I didn't see your message earlier that I should speak closer to the microphone. I now am trying to do that, but I didn't see it earlier. So if you didn't hear me in some situations. So that the person can be pregnant and some relative generates the, I guess, the baby in the family, that the person can be pregnant. Children, okay. So this is usually this case of altruistic surrogacy. So in past, there was this situation where a family relative, let's say the aunt or the sister of a woman, would carry the child and then give it to the couple who couldn't have children. I would say it's less problematic than commercial surrogacy, definitely, but it's still problematic because again, the child is understood as an object, which then again is the pride of one of the biological parents. So he basically has two mothers, and this situation he's put in already from his birth. So again, I think even though less problematic, I think from human dignity perspective, it's still problematic because child is again viewed as an object for let's say the legitimate desire of parents to have children, which is a legitimate desire, as I said, but again, it treats the child as an object to satisfy this wish for a child. So I would say yes, again, it would be problematic from a human dignity perspective.
Another question is, do we have any numbers of how often such especially problematic situations like baby menji occur?
Well, there are two sides to the answer. We don't have, let's say, statistics on how many. We maybe have statistics of how many persons who were conceived through surrogacy had Down syndrome or things like that. But it's very hard to track these contracts because they're private contracts usually. So they don't necessarily have to be reported to some kind of higher authority. They are many times resolved somehow internally between the parties and agencies. So there is some monetary compensation to which happens. What we know, again, are these situations which come to the media, and then there is quite a few of them, and those which come to courts, and there is also quite a few of them. If you just Google, let's say, problematic surrogacy cases, or there is baby N, and well, many of these babies, which are usually known just for the name to protect their identity. So you can find many other cases besides baby Manji and baby Gami. So yeah, there are numerous cases like that. There is no official statistics on how many, and it would be also a question how to classify, let's say, these problematic cases, because all of them differ to an extent. As you can see, also the case of baby Manji and baby Gami differ from each other. And then the question is also whether the thing is resolved without the court. So the parties somehow with the agencies and attorneys manage to settle, usually through larger payments or whatever. And then we have those cases which come to courts, and these are known. And the numbers are known. I'm not now, I don't have in my mind the exact statistic out of all cases, how much is that.
What reasons do intending parents usually cite as to why they pursue surrogacy rather than adoption?
Well, there is wish to have a biological children. So this is one of the cases, one of the things. The other thing is that sometimes for parents who have money, surrogacy is easier. You basically pay someone else to do it for you. I mean, you sign a contract, you pay, and then all this pregnancy and all these things happen somewhere else, and you get a newborn child. In adoption, you usually don't get a newborn child, yeah, because in adoption sometimes you will get a 3-year-old baby, or 1-year-old, or 9 years old, but it's never a 1 week old baby. So you usually, so it's a wish to have a biological child, but as we said, it's not always that the surrogate mother, the child born through surrogacy will be biologically yours. Sometimes the biological materials is from other parties. The other reason is that it's in a way easier if you have money, because you get a newborn child immediately, and often you can also choose some of the biological characteristics if you choose the sperm donor or the egg donor, while with adoption you get what you get. Basically in adoption you submit, you sign yourself for adoption, you state some characteristics, like would you accept the child which has some kind of let's say intellectual problems, or the child which was abused, or how old the child you want to accept. So you can put, I only want children younger than 2 years of age, or I want until 7 years of age. And some people say, well, I also want a teenager, because usually people who sign up for adoption rarely want a teenager, they want a very young baby. So for all these reasons, surrogacy is many times easier. And then obviously there is the question of gay couples. So sometimes they want to have a child, especially if the laws in which they live don't allow them to adopt as a gay couple. So they sometimes want to get a child through surrogacy. Sometimes they intentionally go to courts to challenge the laws on adoption. Well, but that's maybe a more complicated story. So usually it's this biological wish for a child and question of the surrogacy sometimes being easier for the couple.
Thank you. Do you know the percentages of how many surrogacy is done for non-profit but altruistic purposes?
How many in total?
Percentages. How much percentage is done for altruistic purposes?
Well, the percentages in the literature, the percentages differ. Yeah. So, and usually what happens is that the scientists who study that, they try to, estimate the numbers of altruistic surrogacy, because altruistic surrogacy is not always found in statistics. As you mentioned in the beginning, sometimes it happens that the couple finds a willing mother who will carry the child. So it's not always in the statistics. So sometimes they say it's 2/3 altruistic, 1/3 commercial, but we should take this with a grain of salt, obviously, because it cannot always be established so easily. And the other question is how countries basically codify their laws. So as you know, sometimes they will say we allow only altruistic surrogacy, but then the big surrogacy market will boom because of the reason that there will be also donations and in-kind gifts and things like that. So it will be officially viewed as an altruistic surrogacy, but in practice it wouldn't differ from commercial surrogacy, apart from the taxation question.
Thank you. And the next question is, after a surrogacy negotiation, what happens when surrogate mother wants her child back?
Yeah, well, this happens quite often. So because of this, the thing is this peculiarity of the childbearing and pregnancy. The mother cannot know so easily beforehand how she will react to the baby. So obviously a hormonal connection, emotional connection happens, and it does happen that the mother doesn't want to give up the child. Now, then the question is about the legal framework where the contract was being made. So as we said, if there is no legal framework for surrogacy, then the contract is not enforceable. Yeah. So if the mother says, I want to keep the child, there is nothing which can prevent her to do that because the intending parents cannot enforce the contract. If there is a law in the country where which allows the surrogacy, then she would be forced normally by law to give up the child. What can happen sometimes they foresee that in the contract. So sometimes there can be a clause that if she wants to keep the baby, maybe she'll be allowed, but then she has to pay a large sum of money, which she cannot pay, then she gives up the baby. So there are different kind of scenarios which can be foreseen, and then if there is a law which regulates surrogacy, then the contract can be enforced, and then she usually needs to give up the baby. The law forces her to do that. If there is no, then no one can force her to do that.
So the next question is, considering the case in Kiev that you mentioned earlier, which seems unresolved from the point of view of child protection, can we say that the European Union does not fulfill and does not protect the fundamental principles of its treaties?
Yeah, well, Kiev is not in the European Union. You know, Ukraine is not. Well, Council of Europe is. Now, maybe we can speak in terms of Council of Europe, because Council of Europe also has treaties which are obligatory for member states. Ukraine is a part of Council of Europe, so I guess you know, but maybe I will just shortly give the introduction. Council of Europe is not a European Union body. It has 48 member states, basically Russia, everything from Western Europe to Russia, apart from Belarus. So let's say also Serbia, Albania, Ukraine, and many other countries are part of Council of Europe. Now, this discussion about surrogacy in Council of Europe wasn't resolved with a resolution, precisely because there is no consensus among countries. So some countries do legalize both commercial and altruistic surrogacy, some others do not. So there was no consensus to either prohibit or to regulate surrogacy because countries couldn't agree on that. All the treaties rest on consensus, so all signatories sign them. But so I think you can derive from fundamental treaties of Council of Europe, of United Nations, that surrogacy is against human dignity. But this is the question of the law, because when it comes practice, then it's also often a question, how will you twist and turn all these notions to make it fit into the treaty or not fit into it. So since there was no explicit condemnation, for a law point of view, Ukraine is not, or Council of Europe or European Union is not contradicting its own treaties and fundaments. I again say from the point of view of law or positive law. Now, from the point of view of ethical principles, I think the country like Ukraine, which does that, or Council of Europe, if it would allow that, he does violate human dignity and should do something to stop it. And the next question is the question of sovereignty of the countries. Now, even if Council of Europe would condemn it, how can it, what it can do to force Ukraine to implement this condemnation, that's another and very complex story, which we probably shouldn't go into right now.
I'm very happy to see so many questions, and they are still coming, but unfortunately we are slowly running out of time. So our last question is, would the speaker kindly share the slides after the session?
I have to ask Elizabeth, what is the official policy of the webinars? Normally, I wouldn't have a problem to share. I think I can share them. For me, it's okay.
If you're fine with it, then we can definitely share it. It's your intellectual property. You can share it as a PDF maybe instead of a.
Okay, I will then turn it to PDF. I will send to Eva and Elizabeth, and then they will send it to you.
Okay. And now is photo time. That means that if you can, please turn your cameras on and we'll take a photo together, and it will be later posted in our social media. It would be nice to see you all, or everyone who can. And Elizabeth will take photos, so take us when we have to smile.
I will tell you, just a few more people I need to to turn on their picture, maybe because they're on the first page. Maybe Sylvia and Alice, Gracia, if she can, and Richard. Okay. Awesome, thank you. Okay, so please, everybody smile. There's so many people, so there are 2 pages, so please keep smiling. Got you. Perfect.
Thank you, and thank you for coming here all today. So we'll have our next webinar soon, and of course you will be notified by email. And I hope to see you there also. So thank you all for coming.
Thank you.